Hello, I'm Becca King-Reed. You know, the economic crisis has triggered a record number of foreclosures in California. But homeowners aren't the only victims. Renters whose landlords are in foreclosure may not know their rights under the law or where to get help. KTEH is working to connect our audience with community resources. And with me to do that is Shirley Gibson, a housing attorney with the Legal Aid Society of San Mateo County. Now, how do you, if you're in foreclosure and you're a landlord, are you required to tell your tenants about this?
No, there's no legal requirement that a landlord go to their tenant and say, look, I'm in financial straits, let me lay it out for you. And so a lot of tenants who don't have a close relationship with their landlord may have no idea, and there's no legal obligation on the part of the landlord to disclose that.
So how can you find out? Can you look on your own and determine this if you suspect?
You can go to your county recorder and find out if, for example, a notice of default has been recorded. But the entity that's doing the foreclosure, that's recorded that notice of default, is also obligated to tell tenant occupants when there's going to be a trustee sale, a foreclosure sale on a property. There's a law that was effective September of last year, actually, that requires lending institutions, banks that are going to do foreclosures, have to simultaneously notify tenant occupants of a property if there's going to be a trustee sale.
So once you're down to the trustee sale, there's not a lot of time left, is there?
That's right.
So what rights do you have during this process?
Well, obviously, if the landlord is still the landlord, then the tenancy is still in effect. So even at the time that a notice of trustee sale has been recorded, when the tenant learns of that, sometimes their instinct is to stop paying their rent. Actually, while the landlord's still the landlord, they are still entitled to the rent. So until the trustee sale is completed and the landlord actually loses ownership, the tenants are supposed to continue paying their rent.
Now, if you have a lease, you haven't rented month to month, but you actually have a lease on the property for a year or 3 years, do you have to move when the foreclosure happens?
Not necessarily. There's a new law in effect, federal law, that now says that that lease needs to be recognized by the new owner after foreclosure, whether it's somebody who came along and bought the property in a foreclosure sale, or whether it's actually the trustee that took the property back under the sale. And so that new owner, they step into the shoes of the landlord and they have to fulfill the completion of that lease term.
Now, if you are a month-to-month renter, can you be asked to leave because you don't have, well, I tie to the property for 3 years, could you be asked to leave immediately at the end of your month's rent?
No. Again, new law says that 90 days notice in writing has to be served to the tenant household in order for that tenancy to be terminated. And you have the full period of the 90 days to go about the tenancy, paying rent to the new owner before you'd be obligated to leave. Again, we haven't seen that tested a lot because it's a brand new law. So there are still lending institutions, owners after foreclosure, who are out there serving shorter notices. 30-day notices used to be the law, 60-day notices used to be the law. So tenants need to be aware of that. Don't take a notice that they receive just at face value because sometimes it's not in compliance with newer laws.
Sometimes it's not really the person who should be telling you this too, isn't it also sometimes?
That is very much the case. So just like you shouldn't take a notice at face value for, oh, this says I have only 30 days, that must be right. You should never trust that a real estate broker who comes to you and says, there's been a foreclosure, you have to leave now, or don't pay rent to the, to the new owner at all. Pay it to me. These are the sorts of things that you need to investigate before you do anything about it.
Okay, now what about rent control? Does that protect you during foreclosure?
If you live in a rent-controlled jurisdiction, the odds are that you have some added layer of protection. And so there may be exceptions to that, but you should generally investigate any special law that would be protecting you if you live in a jurisdiction that generally would have rent control.
Now, if you notice any of these things are happening to you or you just don't understand, where can you get legal help if you're a tenant?
There's some great resources out there that have been developed. If you've received legal documents, service of some kind of eviction lawsuit or court papers, you should go to your local legal aid. That's the sort of situation that really warrants advice from an attorney because there are some quick deadlines and quick decisions to be made around that. Even if your name is not on that lawsuit. If it involves your property, even if it's your old landlord's name on the lawsuit, you should do something about that, or at least make an informed decision if you're not going to do something about it.
Thank you so much, Shirley Gibson of the Legal Aid Society of San Mateo County. For more information and links to organizations that can help, go to our website at kteh.org.